Thank you. Please be seated. This is the time set for oral argument in 1 CV17 0561 U et al. Versus COLES Properties LLC. Council, we've made a decision while we were waiting to be called in that we're just going to take we're not going to leave the bench between the matters, but if you need to set up or a moment, we'll let you kind of reset yourself, and then we'll go right into the second argument. So that's how we'll take up these matters this morning. As you know, each side is allotted 20 minutes for argument. Appellant may reserve a portion of that time for rebuttal. If you wish to do so, you'll have to keep track of the time using the podium clock. Out of respect for counsel and the court, I ask that those in attendance please make sure your cell phones are off or on vibrate. Counsel, we have read the briefs. We've conferenced the cases this morning. We encourage you to keep that in mind when you present your arguments today. The proceedings will be recorded and posted to YouTube, so before you begin your argument, please state your name and the party you represent. So with that, counsel, for appellant, you may proceed.
Good morning, Your Honors. Trevor Fish. I am the attorney for the appellant COLES Properties LLC, and representing in both. Well, I'll give my next appearance for the next oral argument, but representing appellants for both case. As the court is familiar with the underlying issues, the background of this case, I'll try to just hit some of the facts that are just, I think, most important with respect to this matter. As cited in the briefs, this really is a case of competing equitable mortgages. There's some issues with lis pendens, there's issues with a quitclaim deed, but essentially it is competing equitable mortgages. There's reference to a constructive trust, also to equitable mortgage. I believe that the default judgment says and or, that a constructive trust and or equitable mortgage was granted to the appellees. Both sides truly, or apparently were victims of fraud. Certainly my client was with respect to COLES with respect to Daryl Knock and Imagine Enterprises, but as both sides have said, or I believe expressly mentioned in the briefs, they were taken by this Daryl Knock and Imagine Enterprises. I'm not sure if it was referenced in the briefs, but there is an ongoing, or as far as I am aware, it's ongoing FBI investigation against Daryl Knock and Imagine Enterprises. But so you have the issue of a specific parcel, a specific piece of property that multiple parties are trying to claim an interest in. The default judgment that my client sought to set aside, it was entered January 4th, 2017. With respect to the underlying trial court matter, my client, COLES Properties, was not named a party in that case. And that's important to note, is that they were never specifically named or identified. Also of note, the constructive trust or the equitable mortgage, although there's three individuals, and these are Chinese citizens that I often refer to as Yu, He, Li. That's the last names as indicated on the pleadings. There's the three individuals with the Chinese investment that they give three separate promissory notes. The promissory notes are identical, all three are identical, but for some reason the constructive trust or equitable mortgage that was obtained was only for the appellee, the plaintiff, and the underlying matter, Song He. So we have an equitable mortgage constructive trust just for one of the individuals. And I bring that out because if their claims are identical, then essentially there should have been a constructive trust or equitable mortgage for all three of them. They claim that the promissory notes were to be secured by a first priority security interest in all of the tangible and intangible property of the borrower, so of Imagine Enterprises. But it was sought and claimed by only one of them.
Why does that matter?
Well, It's interesting because in the complaint for the underlying case, they claim that the funds from Song Hee went towards the purchase of the property. And I believe that's why, I'm not going to make, I can only make suppositions or make guesses at why just one was included and not all three, but it appears from the complaint that their belief was that the monies from Song Hee was the only individual that actually went towards the purchase of the property, because it appears to have been dated.
Kelly's response, and I may be misremembering, so you or he can correct me. I think he says that we're only pursuing this one, but the parties, the appellee's side of it agreed to basically let one person be a representative party for the other two. So I'm not sure why it matters that there's only one that's really active in the litigation.
Yeah, but here's that explanation, and I don't want to. I referenced the second trial court matter, and I guess
it's very interrelated.
Yeah, that's why it's important, I guess, to bring up some of everything that's filed in there has been referenced in the pleadings. We make cross references to the record of each. But it appears that that explanation is given after it's pointed out bank records are supplied, and it turns out that the funds weren't actually wired or transferred until after the purchase of the property. So that's in complete contrast to the complaint. The complaint in the underlying first trial court matter says, upon information belief, the defendants used the proceeds from the Song Hee loan and the Song Hee note to purchase the Scottsdale property. And that's cited directly from paragraph 65 of the plaintiff's complaint. Later, so in the second case, the second lawsuit, it's discovered that that's untrue, that actually those funds weren't used. And so then there's an explanation provided. Well, the three of them have agreed that only Song Hee is the only one that's going to make a claim against the property. That's why I pointed out, is because there's conflicting allegations, and it's clear, and I believe it's not disputed now at this point, that none of the funds from Song Hee or from any of the other appellees, none of their funds were used towards the actual purchase of the property. Unlike with my client.
And that matters because, why? Because you're trying to challenge the equitable lien that was established in the default judgment.
Correct. The basis for their equitable lien, it's not because actual money went towards the purchase or the improvement, the repair. That's not the basis for their equitable mortgage. It appeared so at first in the plaintiff's complaint, but now that we look at it, that can't be grounds for their equitable lien. So their only grounds for equitable lien is because the promissory note says that it was supposed to be secured against all tangible and intangible property. So when given the analysis of an equitable mortgage, equitable lien, that's one of the factors to consider is, okay, where was this money used? Did this money go towards the property? If it is, then of course that is a better grounds or better argument for creating that equitable lien. Also of note is that their promissory note, it does not identify this specific parcel of property. It says secured against all tangible and intangible property, but it doesn't specify this particular parcel, not by address, not by legal description, not by parcel number. And it's also, as I pointed out, it's a signature that's unnotarized, it's not acknowledged, and it's unrecorded. It's not recorded with the property records of the county recorder. In contrast, COLES Properties equitable mortgage claim, it relates to a joint venture agreement that was entered into before the purchase of the property. The joint venture agreement, it identifies this particular subject property, and just as with their claim, our client claims that it was also supposed to be recorded, but of course this individual for Imagine Enterprises did not record it. So we have, in contrast, a claim where actual money went towards the purchase of the property, where the specific subject property is identified and described and the address is listed within. The joint venture agreement, it was supposed to be so that my client's funds were used towards the purchase, the fix-up, the repair improvement of the property, and then net proceeds were supposed to be split between the parties, and of course that never happened. The agreement was that there was only going to be one singular encumbrance upon the property, one mortgage, and by doing these other notes, these other loans. Of course, that violated their agreement, and it's something that my client was unaware of. And there's not a dispute as to that. My client, and I've referenced it in the memorandum, my client actual money, the $15,000 in earnest money towards the purchase, another $46,000 in excess of that, a wire payment into escrow on the day that the property closes. So these are actual funds for my client. And my client's, the individual that owns the LLC, it's not something that he's a big wheeler-dealer. I mean, this is his life savings. It's something that's always hindsight's 20/20. If we could go back, any attorney would recommend that he do things differently, but he's stuck now where he's at, trying to get something back of his life savings. So that's where he's, and I didn't mean to go ad nauseum listing all the amounts that he's been put into the property, but when I list the wire payments, I mean, he really has put, according to the records that we have, almost $170,000 that went towards this property. And that's why the fight over this, even though there's a first mortgage, the property, there was excess equity in the property. It was actually listed under contract for sale at the time that my client became aware of the Liz pendants. It wasn't in my client's name yet. It was still in Imagine Enterprises. They had it under contract for sale. Then the issue comes up with the Liz pendants, and that's what necessitates after that, where my client gets the quitclaim deed. Daryl Knox trying to wash his hands and eventually runs, flees out of town, out of the country, I believe. But this is a matter that it all happens within, you look at the Liz pendants recorded, I believe it's September 30th, 2016, default judgment, January 9th. So a matter of just over 3 months that process happens.
So when did your client know about the notice of Liz pendants?
It would have been just right before that we obtained the quitclaim deed. So it's December 8th, 2016.
So why didn't your client immediately seek to intervene in the litigation at that point?
So what was first done is a notice given by certified letter to opposing counsel of a claim in the property, along with the notice of that we believe their Liz pendants is wrongful. And at that time, our office is retained. We're preparing a motion to intervene. The motion to intervene is filed. When we filed the motion for intervene, there's no record in the Superior Court records of any pending hearing dates, default hearing, default judgment. Nothing of that's in there. We only find out after we file the motion to intervene that, a default judgment was already granted. Because it really is a period of, you look at the procedural history, just over 3 months. So it was a quick process.
So how did the trial court err then in denying your motion to set aside the default judgment? What are your specific reasons for why that's error?
The first issue of
I'm sorry.
No.
Just so I make sure I'm clear. Your motion to intervene was filed before the default judgment motion was docketed, or?
It hadn't been updated in the online case history, so I don't know if it just hadn't been docketed by the clerks yet. Okay. But it's filed before any default judgment, and there was no hearing, a hearing date, default hearing date, and there's the letter to opposing counsel, phone calls to opposing counsel. We're unaware that there was even a default hearing that had been scheduled.
But the default hearing took place after you filed the motion to intervene.
No, the default hearing took place just immediately before, because the default judgment's granted 5 days before, because it was on the 6th day that we filed a motion to intervene. So it's a 5-day period. They get default judgment. 5 days later, our motion to intervene's filed. We don't know that there's a default judgment. Otherwise, we would have filed a motion to set aside the default judgment in connection with our motion to intervene. And I hope it was clear with our memorandums. Originally, the motion to intervene's denied, and it was Judge Anderson, I believe that. She originally denied that because there was some discussion that if we stop, or if they grant the intervener, then they won't be able to stop the trustee sale that was pending. That was also part of our motion, was worry about the trustee sale that was coming. So Judge Anderson denies the motion to intervene, but says you can refile it after you stop the trustee sale. So trustee sale stopped. They pay off the first mortgage. We come back, file our motion to intervene in connection with the motion to set aside the default judgment. The motion to intervene is granted, and that's Judge Anderson that grants that. So that's the first issue on appeal where there's conflicting trial court rulings. So we have Judge Anderson that grants the intervener, that finds that there is grounds that we are a proper intervener in the case. And then we later have the Commissioner Stephen Holding that denies our motion to set aside the default judgment. And he does it on the basis of just we don't have standing. The COLES property doesn't have standing in the case. So that's where I argue.
So now I answer Judge Brown's question. So how did Judge Holding err, or Commissioner Holding err in that case?
Yep. The Commissioner erred because if there's grounds for an intervener, then it follows that there's sufficient grounds to have standing in the case. Maybe you don't have a winning argument, but at least you have, a ticket to ride. I mean, that you do have issues that would create. It's similar. Standing for an intervener is going to be same as having standing in the case. So that's the conflicting
law of the case. Then, since you'd already been granted intervener status, you
correct
ipso facto have standing to pursue the default judgment.
Correct, and that's the insufficient or the conflicting ruling by the commissioner later on that conflicts with the prior ruling.
And for argument's sake, let's say we agree with you, that we ultimately agree with you that that you had standing based on the motion to intervene. Do we also have to reach the merits of the motion to set aside, or would that be something that the trial judge, the Commissioner Holding, or whatever judge should take up in the first instance?
Yeah, it's for the motion to set aside. It wasn't addressed. I mean, he didn't even get to that step. That he just said that there wasn't standing to even address the motion to set aside the default judgment.
So you agree that it might be advisable to have the trial judge address that in the first instance?
Correct, that it should have been either the trial judge, Judge Anderson, addressing that issue, or even the commissioner didn't even get to that point of addressing the grounds, the actual merits of the motion to set aside the default.
You don't think it's appropriate for us to address that issue? I think that's Judge Brown's question.
Yeah, that's what I try not to ever say, oh, you can't consider that, but if it's not an issue that's before the court, I mean, it wouldn't be the first time, but generally it's not an issue that's before the court because that wasn't a specific ruling that was reached by the trial judge.
The remand is proper, you believe?
Correct.
To the trial court.
Correct.
I understand your argument about law of the case, but let's kind of flip it on its head and say, what if we think that the commissioner or Judge Anderson was wrong to grant intervention? What's your best argument that they were correct to say you have standing via intervention at that point?
Well, if you look at you've got intervention as a matter of right, which we cited that both as a matter of right and as permissive. As a matter of right, the four analysis, the four steps, that the motion is timely, and certainly with as fast as things were going, the motion was filed. We ended up missing, default judgment already granted, but 5 days after that, we filed the first motion to intervene. So it certainly was timely. I mean, as quickly as can be expected by finding out about this, the claims, the lis pendens, my client retaining counsel. So files a timely motion to intervene. Second, that he has an interest relating to the property or to the subject matter that's before the court. Certainly he has an interest in that. Third, that the case impairs or impedes his rights in the property, and it meets that as well. And then fourth, that his interests are not adequately represented by the parties already involved. The fact that you have a defaulted party, of course, my client's interests aren't going to be represented or protected by that defaulted party. So it meets all four requirements of intervener as a matter of right. For permissive joiner or permissive intervention, along with all that, it's also the courts look at whether or not it's timely, whether or not a party's prejudice or that it delays the existing parties. We don't believe that it delayed anything. This is a quick, fast default matter, and that there's common questions of law and fact. So it meets all for permissive intervention, and also for intervention as a matter of right. It meets all the requirements for that. And then of additional concern or additional issue is that we have equitable mortgage claims that arise prior to the lis pendens, and then we have title claims that arise after the lis pendens, after we get the quitclaim deed from Imagine Enterprises. There's two grounds that go on. If they say, well, you don't have standing because there's no equitable mortgage claim, well, then we go under, well, we have defective title. It's a defect because of the lis pendens, but we still stand in the shoes of Imagine Enterprises. And that's what the appellees have argued, and argued that because of our lis pendens, you only get what title is passed. And we argue, fine, if we get what title's passed, it's still defective title that we needed to stand in the place of his shoes. We needed to be allowed in that case so that we could make the arguments that should have been made by Imagine Enterprises. And that didn't happen. So that's where it's two separate courses to get to that same conclusion of standing. I have 30 seconds left. If I can save that for reply. I don't know how much of a reply that will be, but.
All right. Thank you, counsel. Mr. Hundley.
Good morning to all of you, and I am Richard Hundley, representing the plaintiffs and appellees. And just to focus just on this appeal, this is a denial of a motion to set aside a default judgment. So the standard of review is very high. Did the trial court abuse its discretion? The motion to set aside the default judgment was brought under Rule 60. And Rule 60 indicates that the only parties with standing, or the only ones with standing to move to set aside a judgment, are the party or its legal representative. Coles Properties was not a party to the case. Coles Property was not a legal
party the minute the court granted the motion to intervene.
They were. I don't know. Maybe technically that's true. But they were not a party when the default judgment was issued. You asked about the timing on all this. The default was entered, I think, in early.
Opposed their motion to intervene?
Yes.
So it was litigated. It wasn't just granted as a matter of course. So we've got the court saying, we've got court one saying, or judge one saying, you are a party, at least going forward.
Mm-hmm.
And then you have court two saying, but you're not a party for purposes of Rule 60.
Well, I mean, arguably, I will say that they're a party once they intervene. But the judgment wasn't against them. It's the party or the party's representative against whom the judgment or order was issued who has standing to bring the Rule 60 set-aside motion. The default judgment is against Imagine Enterprises and Darrell Knock. It's not against Coles Properties, which takes us to a very bizarre situation. What would have happened had the court set aside this default judgment? The default judgment against against Knock and Imagine is set aside so that those entities, I guess, could oppose the complaint, but they didn't want to. We even cited something in the record showing that they were aware of the default and they weren't contesting this. So, yes, Coles was a party once they intervened. They did not have standing to bring a motion to set aside a default judgment directed against another party. And I can't find any case law where this has ever been approved.
Why aren't they a successor interest?
They're not a successor. They're a creditor. They're a creditor of.
But they own the property now that you're seeking the default against, or at least they claim to.
Well, and that's kind of an issue for the second case, but that's the fallacy of this whole first appeal and the motion to set aside. Coles Property is saying that our rights have been affected by reason of this default judgment. That somehow this default judgment precludes them from asserting their claims to the property. And this is more an issue in the second case we're going to hear. They argue that the trial court in the second case just adopted the default judgment and found that Coles Properties had no interest. And that is not what happened. Coles Property was not affected by the default judgment. Coles Property litigated its claims to the property in the second case. Evidence was put on, and their claim failed. And it failed for two reasons. The first was because of the lis pendens. We have competing claims against real property. Under Arizona law, the priority of those claims is determined not by when the events happened, but when something was recorded. That's in the lis pendens statute. It's discussed in the Mammoth Cave case. It's also in, I think it's ARS 33411 and 412, that unrecorded interest have no bearing, have no standing against a good faith purchaser or lender or other acquisition for value. So Coles Properties really had no interest in the first case because its claims to the property were not litigated or affected in that case. They were affected in the second case, and we'll talk about that in a bit.
But the validity of the Liz pendants and the validity of your claim to equitable mortgage was established via the first case.
Yes. And then it was confirmed in the second case. We did, in the second case, when we did our motion for summary judgment, we didn't just say, we have a default judgment that gave us an equitable mortgage constructive trust, so rubber stamp it. That's not what we did. We put on the same evidence. We put on more evidence.
But you're saying that the court essentially ignored? Did the court say, I'm not even looking at that default judgment? I mean, I'm pretending it's not even there. I'm giving you a brand new equitable lien in this amount.
The court allowed us to foreclose the equitable lien we had. The court ascribed a dollar figure.
That's the key. I mean, you established an equitable lien through a default judgment.
Yes.
A substantial equitable lien.
Yes.
Well, that had some bearing on the second lawsuit.
Well, right, but it was litigated whether we should have that lien and whether we should have that amount. There are also facts that took place after.
You didn't argue the default judgment at all because
No, we cited it.
Reading in the transcript in the second case, there's discussion of the default judgment.
It's discussed, but we did. There was a significant event after the default judgment. That is, the senior lender was foreclosing. So one of the plaintiffs, in our case, stepped forward and paid off that first loan, paid over $500,000. So in the second case.
And that's not contested. I don't read either party is arguing that that's a priority over everything else, right?
But the court in the second case did not say, you have a default judgment, therefore I'm giving you this lien. We moved for a summary judgment to foreclose a judicial lien. We established why we were entitled to we established the amounts owed, why we were entitled to the lien, why it was superior to Coles Properties' claim, and therefore why we could foreclose. That was all established in the second case. It was not just a rubber stamp situation.
But the whole reason that lien existed was because of the default, right?
Yes, but we proved why. Well,
you proved by what?
The reason it was appropriate for summary judgment is because there's no disputed facts because the prior court had granted the default.
The reason we got summary judgment is because we put on the evidence again as to the amount of the loan, the promise of security, evidence of the payment of the loan to Imagine Enterprises, and the payoff of the first position deed of trust. We put on that evidence again and expanded on it. We got our summary judgment because of that proof, because the defendant could not raise anything to dispute that. They couldn't raise a tribal issue of fact.
Let's go back to the monies, the three plaintiffs. Were any of those monies used to purchase the property?
Each was told that it was going to be used to buy property.
That's not my question.
But they were lied to.
Okay.
The property was
it
acquired.
seems like there's a lot of lying in this case. I mean, but unfortunately, for both of your clients. But just so I understand, is it your contention that any of those your three clients, that any of those funds were actually used to purchase this property?
No.
Or improve it?
Possibly.
You don't know?
We don't know.
How's that not a factual question?
Because our right to the constructive trust or the equitable mortgage was because of the language in each note saying that your loan is going to be secured by a senior position.
You know, it doesn't say, it says first.
First position. First position, security interest.
Well, why didn't that happen? It didn't happen. You weren't put in first position.
Right, because they got defrauded. The bad guy got the money and then no contact.
Okay. So
our equitable claim to the property.
That was all litigated in the default judgment hearing.
It was litigated in both. It was litigated in both. When we were moving for the default judgment, we didn't know about Coles Properties. They had no recorded interest in the property. We didn't know that they existed. They didn't arise.
You didn't know they existed?
We did not know they existed.
And they sent a demand letter?
After we got the default judgment. After the default had been entered.
I'll have to look at the record because my recollection was that the demand letter was sent before.
I think on the same day that you moved for default judgment.
Okay. But we'd already had filed our suit. We already had our Liz pendants.
But the
Right.
court hadn't ruled on the default
Correct.
judgment yet.
And you
Correct.
never notified the court that there was this new claimant to the property before the
Well,
default judgment was entered.
it's up to the Cole Properties to do something. We're not supposed to file pleadings for the opposing side. We're kind of going beyond the default judgment, but again, I want to assert that when we were doing the default judgment, what we thought was the clients were told your money is going to be used to buy property.
So are you withdrawing your statement earlier that you didn't know?
Didn't know what?
You said a minute ago, we did not know COLES existed when we filed for default judgment. I just-
We did not know COLES existed when we filed the lawsuit and started the process. At some point around the default stage, yes, COLES speaks up.
Before the judgment was entered, you were aware of COLES.
Well, that I'm not positive about, but if you have, I didn't check that this morning, but if you have it in your notes, I will accept that. It all happened pretty close.
Okay.
But again, the default judgment doesn't affect COLES' rights. It doesn't say COLES doesn't have a lien. It doesn't say COLES has a junior lien. It doesn't say any of that. All it says is that as for the plaintiffs against Imagine Enterprises, you're awarded this amount and you have equitable mortgage constructive trust. That leads to part two. We then have to foreclose that lien, and in that case, you would include as defendants anybody with an interest in the property so that they can assert their rights. COLES Properties was included. The senior lender was not included because we paid that off before.
Default judgment, by establishing the validity of the Liz pendants and the equitable lien, doesn't, and it might be that I'm just confused, but doesn't that impact their ability to argue that, no, you don't, that Liz pendant wasn't valid, and no, you don't have an equitable lien?
Yes, and they argued that in the second case, but they cannot put on any evidence to support that. And in fact, they conceded at least to $500,000 that we were entitled to an equitable lien.
Well, that's because you paid off the first one.
Yeah.
Yeah.
But that was litigated in the second case, and they could not come up with any triable issue. They can't come up with any evidence at all to dispute the fact of the loan, the promise of security, and the loan payoff. Now, the trial court, Commissioner Holding, in looking at the default judgment, didn't just deny the motion based on standing. There's also a comment in his minute entry, matter under advisement, later ruling filed July 27th, where he cites that the Liz Pendente was filed prior to the quitclaim deed. That traces back to an argument we were making in response to the motion to set aside, which is that what COLES Property was trying to do was both unnecessary and futile. Unnecessary because its rights were not affected by the default judgment. It would be litigated in the second case, which was then pending. Futile because our Liz pendants was recorded before COLES Property received the deed. So when COLES Properties received the deed, they received it subject to any claims that we had.
So it's subject to all viable and provable claims and claims that are ultimately successful.
Yes,
Yeah.
yes. If in the second case it was found that we were not entitled to the equitable mortgage for whatever reason, that would have been a different result, but that's not what happened here. There was absolutely no evidence brought by the defendants in that case
So
to
let's just
dispute
walk
it.
this through procedurally, just like we did with Mr.
Sure.
Fisher. Let's say that we disagree when we get to the second case in a few minutes. That for sake of argument, we find that we think there are material issues of fact, and that case needs to go back. If I understand you correctly, that could happen, correct? But your position would be nothing would need to happen to the default because that's been established. You just go back again and continue to litigate these issues
The second case.
in the
yeah.
second case.
Yeah, but this first case has no bearing really on the second case. The motion to set aside. Well, first of all, the contention that if you have grounds to intervene, you have grounds to set aside. I mean, there's no case law that suggests something like that.
But is there any case law that says yes, you don't? I mean,
Plenty of case law that says to set
that
aside.
an intervener should not be able to, who is a party, cannot set aside a default judgment.
There's nothing that
I
says...
mean, there's nothing either way, is there? There's no case directly on these.
Well, there's the recent Brnovich case where somebody tried to set aside a default, and they said, no, you can't because you weren't a party because you didn't file a claim on time.
But that wasn't an intervener.
That was not an intervener. I mean, I can't find any case where an intervener tries to set aside a default judgment issued against other people, and the reason that doesn't happen is because under Rule 60, only the party or representative against whom a judgment or order was issued has the right to do that, has standing to do that.
How are they not a representative, legal representative?
I'm not an attorney. Legal representative would be an attorney. Coles Properties, at that point, I mean, at some point, it is a party of Imagine, but it's a separate and distinct entity. They don't control each other. By the time of their lawsuit, they are a creditor of Imagine Enterprises.
I'm looking at the rule right now, counsel. It does not say against whom the judgment is entered. So that's what your interpretation is.
It's 60. I think it's 60B now. I don't have it in front of me.
On motion in just terms, the court may relieve a party or its legal representative from a final judgment, order, or proceeding for the following reasons.
And I think that clearly means a ruling against it. How procedurally would it work if you release? How procedurally would it work if Party C brings a motion to set aside a judgment against Party A? Then what happens after that? Party A is probably going to default again. And the reason this first case, I mean, this first appeal, I don't think is even necessary. The motion to set aside was not necessary because it was in the second case that Coles' rights to the property were litigated and deemed junior to plaintiffs.
Counsel, one argument you made earlier that I'm looking through your brief to find, and I'm not sure. You argued that the judge basically denied the motion to set aside via standing and on the merits. And I'm just trying to find in your brief where you made that argument that he addressed the merits of it as well.
I can refer you to the specific ruling. I have that in front of me.
I'm asking about in your brief.
In my
you
brief.
raised the argument that it was decided on the merits as well.
Yeah, bottom of page 5 of my brief. I cite the minute entry.
Oh, thank you. Okay.
And again, I think this I just want to emphasize this, and I hope I'm not repeating myself too much, but this first case is just a red herring. The second case is the important one. The second case is where Coles Properties could stand up, assert its claim, try to create a triable issue of fact as to the plaintiff's claim. It was not able to because plaintiff's claim had priority under the recording statute, and because Coles Properties' equitable claim was gone at that point. It merged into the deed it got when it got legal title. A party cannot have both a legal and equitable claim against the same property. You cannot claim your right to an equitable mortgage in property you own, because in an equitable mortgage or constructive trust, the whole argument is somebody else owns this property. I've been deceived. I have an equitable claim to it. You can't say I have an equitable claim to property that I personally own. Unless any of the judges have any questions? I would at one point. We asked for attorney's fees in this first appeal, and I think it's really appropriate, because what Coles Properties did was intervene on purely a contract claim based upon a promissory note. It's trying to stand in the shoes of parties to that contract, specifically Imagine Enterprises. And I think that not only should that order denying the motion to set aside be sustained, but that as prevailing parties, the plaintiff should get an award of their fees.
How's there a contract between you and your client and Mr. Fish's client?
There is no contract between my client and Mr. Fish's client, but Mr. Fish's client intervened in that case and tried to litigate issues on the contract between my client and Imagine Enterprises. They were trying to represent Imagine Enterprises' argument.
You asked great questions. Let me ask you, you earlier asserted that legal representative means only an attorney. What's your support for that proposition? Because there is some case law that says legal representative in the context, not in Arizona, but in other states dealing with Rule 60, is people who stand in the shoes of the party.
That is true. Yeah, and that's not an Arizona law, but I have seen that in California. So it wouldn't be merely an attorney. I guess a legal representative would also be someone who has a relationship such that way we're allowed to represent somebody else, like maybe a guardian or a conservator.
Maybe someone who's bought property that is.
That's not a legal representative. That's not a legal representative. The issue there is a holder in due course. That's a separate person.
Okay, thank you.
Thank you, Mr. Hundley.
Thank you very much.
Mr. Fish.
So I think it has been cleared up that the appellees certainly were aware of our claim before default judgment's granted. It appears before even default's entered, but truly the issues on appeal that we're asking reversal remand for is because the granting of an equitable mortgage, we don't believe that they had a proper claim for equitable mortgage, and then denying our motion to set aside the default judgment.
And I guess I want to follow up a lot on some of the points that he made, because some of those sound pretty good to me right now, but I guess we can talk about it with respect to the second case. So we'll just wrap this one up here and then go into the discussion of the next one.
All right. Thank you, counsel.
Thank you.
Is there anything we need to do? Give you time.